Hello and good afternoon, everyone. I hope you're all doing well and being safe. The subject of healthcare and medicine has always been of utmost importance and priority to all of us. We've always looked up to doctors and the medical professionals as gods, where as the old Indian saying goes, Vaidyo Narayano Hari. And more so in the pandemic, they have also risen to be our COVID warriors. However, just as any other professional service, all is not well here as well. Medical negligence cases and liabilities against medical professionals and hospitals are on the rise. So, what are the legal principles underlying medical negligence? And more importantly, what is this interface of law and medicine? Well, I have quite a few questions on the subject, and I'm sure even you do. Let's find out more through this webinar on medical negligence liability, interface of law and medicine. And today, we have with us Professor Dr. S.V. Joga Rao, an acclaimed legal expert in the field of healthcare law and ethics. Dr. Rao is a postdoctoral research scholar in the healthcare law and ethics and is presently anchoring the professional activities of Legal Excel Attorneys, which is a law firm of advocates, solicitors, and healthcare consultants. Dr. Rao actively is involved in researching ethical, policy, and regulatory challenges and perspectives, focusing on interface of healthcare law and technology in its multidimensional perspective. He has been conferred the globally acclaimed and intellectually coveted Max Planck Fellowship by Max Planck Institute, Germany. A very warm welcome to you, sir.
Good afternoon. Thank you so much, Ms. Pratima.
This event is hosted by EBC Learning, an online learning initiative of EBC that provides on-demand legal education. I have posted the link to the website on the chat for your information, and it's a platform that helps you learn and win. I'm Dr. Pratima Narayan. I'm the editor and consultant at EBC Learning. We will now begin with the discussion, and please feel free to post your questions on chat, which we will take up towards the end of the session. You could also ask us questions, or you could even post questions. The session is now live on YouTube, and you can also watch this webinar at your leisure and share the link with your peers and professional colleagues. So without much ado, let's begin with the session. Over to you, Professor. I have a few questions to ask you. There is a basic question that I and perhaps many of the participants here would also like to clarify. Is healthcare and medical treatment included within the definition of services under the new Consumer Protection Act of 2019? And what is the position of the 1986 Act vis-a-vis the present legislation?
I think in this particular conversational mode of interaction, this is the best part, because post enforcement of 2019 Act, this is to be clarified at the outset. According to my understanding and practice as well, healthcare, medical care and treatment does fall under the jurisdiction of 2019 Act. There are two reasons. Particularly, I would refer to Section 2, Subclause 42, which gives the scope and ambit of this particular Act, mentioning illustratively certain sectors, but explicitly stating it includes others as well, which means it is an inclusive definition wherein, even though there is no specific mention about healthcare, I think it is a matter to be adjudicated under the provisions of Consumer Protection Act. And your later part of the question, I think it's equally important. What is the position vis-a-vis 1986 and 2019? In fact, if we refresh our memory, though the first enactment was enforced in the year 1986, till about 1994, where Honorable Supreme Court decided in famous VP Shanta case versus Indian Medical Association. Till that moment, there was a diversity of judicial interpretation starting from Cosmopolitan Hospital case, whether healthcare, medical care falls under the ambit of Consumer Protection Act or not. I think VP Shanta's case clarified. Therefore, even though there is no such kind of explicit mention, there is nothing which shows or reflects contrary to that. Therefore, it is rest assured that healthcare falls under the ambit. And also, post enforcement of 2019, several cases are being filed at different commissions, district, state, and national commission also. That also indicates that the consumer courts have the jurisdiction.
Thank you, sir. So my next question to you is whether there is any change with regard to pecuniary jurisdiction as under the 2019 Act, and what is its impact on medical negligence cases?
Yes, I think 2019 Act in a very unique manner has modified the then existing principle pertaining to not only pecuniary jurisdiction, but more particularly quantification of such pecuniary value. In the recent act, it is mentioned very clearly the amount that is spent either for purchase of the product or for availing the services only to be considered for the purposes of pecuniary jurisdiction. Which means, suppose as a patient, I spend X amount, only that amount is to be taken into consideration for the purpose of deciding whether it falls under district, state, and national. How is it different from earlier legislation? In the case of earlier legislation, the focus was on the quantum of compensation that used to be claimed by the complainant, which means not only the expenditure that is incurred towards availing of service, but also under various heads, either mental agony or loss of earnings or consortium. There are so many other heads under which they used to quantify, put together, which used to be called as global compensation or umbrella compensation. That amount will be considered. Suppose if I spend 1 lakh and if I include, say for example, more than 20 lakhs, in the earlier jurisdiction, it falls before the state commission because the total compensation exceeds 20 lakhs. But whereas in this particular act, the jurisdiction in terms of 1 crore below, 1 crore till 10 crores and above 10 crores. I think that is how district, state, and national commission. But how do we quantify only the expenditure that is incurred towards either purchasing a product or paid for availing service, but not other heads of compensation? I think that is something very, very important change that has come about.
Okay, so to sum up, to my understanding, it is presently the value of the product or services that is to be considered and not the value of claim, which was the erstwhile legislation.
Absolutely.
Thank you, thank you. This was a very important clarification for us. And now moving to my next question, with regard to medical negligence case, how and on what basis limitation period gets computed?
Yeah. I think unlike in other cases, I'm talking about the consumer cases in general. Unlike other cases, I think when it comes to medical negligence cases, limitation plays a very, very important role. At the outset, let me clarify, though it is provided as a 2 years limitation period, depending upon the cause or ground that gets furnished before the Honorable Commission, the Commission is entitled to exercise discretion. If they are justifiable in nature, then the delay may be condoned on case-to-case basis. That approach is also recognized in the 2019 Act as well. But when it comes to the question, though we know what is the limitation period, the important part of the question is When will it commence? The 2 years period, when will it commence? I think that's a very important question. The most landmark judgment, I think 2011 Supreme Court Shrikant's case, Supreme Court clarified by invoking the discovery rule. And accordingly, the court very assertively stated that because of discovery rule, please remember, the point is, even though it exceeds the limitation period, if the patient doesn't know or doesn't experience anything, the limitation continues. The date on which the patient, please remember, experiences or gets to know, then the limitation period, it starts. I'll give 2 examples, case studies. Particularly, this issue has come about in certain specialist-oriented medical negligence claims. For instance, tubectomy. A woman undergoes tubectomy, and thereafter, 3 or 4 years later, she again conceives. The question is whether this particular point, is it exceeding limitation period? But when she conceived, the complainant claims that despite tubectomy operation, she conceived, which means there is a negligence on the part of the doctor. And accordingly, limitation period should commence from when she gets to know about conception. I think the courts all over India and in majority other jurisdictions also, discovery rule is applied, and accordingly, the limitation period commences, even though she underwent tubectomy 3 or 4 years ago. Doesn't matter. But from the day on which she realizes, from then 2 years. Similarly, in ortho cases, normally what happens is whenever an implant is put in any part of the limb, the post-surgery, the patient may feel better, may get some relief. But after 4 or 5 years, there may be a possibility of breaking of implant or lingering infections. As a result, the patient may have to undergo a subsequent surgery. The point is whether the first surgery date will be taken into consideration or the second surgery. And by invoking discovery rule, there is every possibility the experience of hardship, pain, etc. from that day onwards, 2 years it commences. However, one very important principle. In the case of Shrikant's case, Honorable Supreme Court very clearly, categorically stated, discovery rule requires a close scrutiny of all the facts and circumstances. Whether the person had the knowledge about the pain earlier or from some other date, that requires a close scrutiny. I think that's a very important point we need to. Till date, the Shrikant's judgment of Supreme Court is the valid law as of today.
Okay. Thank you, sir. That was a very important learning for us with regard to limitation period in the context of medical negligence cases. I just want to move to the next question with regard to breach of duty. Now, in medical negligence cases, how does breach of duty and injury owing to such duty gets evaluated and rationalized by the courts?
In my opinion, the most difficult and challenging part in a claim of medical negligence case is about these 2 aspects which you have just now mentioned. Without there being breach of duty and without there being injury owing to such breach of duty, medical negligence is not legally tenable. Now the question is, many a time what happens is, the patient may undergo an adverse consequence, or the patient may die on the operation table. Whether death on operation table, does it reflect medical negligence? Question mark. Similarly, post-surgery, the patient may undergo some adverse consequence. Does that mean adverse consequence reflects medical negligence? I think this is where the interface of law and medicine is very, very crucial. Namely, There is one doctrine called doctrine of causa causans, which means the cause and effect must be directly related. If the cause and effect is either indirectly or remotely connected or related, the claim of negligence falls to the ground. Therefore, it is the most important challenge for the council to prove whether there is causa causans or not. In one of our recent judgments, Madan Super Specialty Hospitals, Honorable National Commission has reiterated this particular principle very clear and mentioned explicitly how causa causans is important. Let me just explain to you one particular case study. In one case, what happened was the pregnant mother was under the care and treatment of a particular OBG, obstetrician gynecologist, and normal delivery was expected. But just before the delivery, she came and she got admitted, and the doctor examined whatever that is required. They have done. Expecting normal delivery, waited for some time, then deceleration started, which means the pace in which the pushing got slowed down. At that point of time, the doctor took a decision, accordingly used, because the scalp of the baby is visible. And accordingly, the doctor used external forceps and used it, retrieved the baby. Baby hale and healthy. Pediatrician came and examined, and mother also doing well. After 5 days, both of them, they have been discharged. Subsequently, mother developed a lot of pain in her knees. As a consequence, she came back to the doctor. Doctor did give some kind of painkillers, etc., but she did not feel any relief. She neither stand or sit or squat and even feed baby. Then thereafter, she approached another particular hospital, and wherein the hospital conducted studies, etc. And then they came to the conclusion that she is suffering from MS, popularly called multiple sclerosis, a neurological disorder. And thereafter, dissatisfied, aggrieved by the doctor who conducted the delivery, a complaint has been filed. And accordingly, the court has taken note of, etc., etc. And during the course of the proceedings, Honorable Justice made one observation. He said, Mr. Counsel appearing for the opposite parties, this is an open and shut case, because it is very clearly written in the document of the subsequent hospital, why did she get this problem? Then he asked the counsel to read the medical record. In the medical record, it is stated that she underwent delivery through external forceps and subsequently developed multiple sclerosis, etc., etc. When it was read out in the open court, Honorable Justice said she started suffering multiple sclerosis post-delivery, but she did not have that problem prior to the delivery. Therefore, it is because of forceps delivery. That is what is the. At that point of time, the counsel made a submission stating there is the doctrine of causa causans, which must be very, very clearly looked into, is there is a difference between sequential outcome and a consequential outcome. Let me put it this way. The later subsequent hospital, when they mentioned about she suffered, etc., etc., but that does not indicate consequential. That only indicates sequential. What causa causans relates is the cause and effect must be directly related, which means the means of adopting external forceps delivery must be the cause for her suffering in the form of multiple sclerosis. I think this is the case study which amply explains how in medical negligence cases this is to be taken note of. This is what is my explanation.
Okay, okay. Yeah, thank you, sir. May I now move to the next question? It is documented that medical science is not an exact science, meaning, thereby, depending on the nature of care and treatment, complications are inherent. Now, how do court rationalize this element in deciding medical negligence cases?
I think your observation is absolutely true. Medical science entails lot of risk factors, complications, etc. From a legal point of view, what is expected on the part of the doctor is the first important thing, through written informed consent, the probable risks and complications need to be conveyed in the language and as understood by the patient or family members. Number one. Number two, whenever we talk about a known complication, it's called casing, known complication. The courts would look into if there is a complication and if it is known in the medical literature and experience, what measures have been adopted by the doctor in order to either prevent or preempt or minimize such known complication. I think these are the two important things which we need to take note. For instance, in any laparoscopy surgery, it depends upon the body part where it is conducted. Maybe cholecystectomy, etc. Gallbladder stone removal, etc. Or it could be total abdominal hysterectomy through lap, if it is. Possibility of bladder injury is writ large. Even a small touch of the instrument may lead to bleeding, etc. Normally, doctors are expected to be alert. And if there is such kind of thing, there is a protocol, what requires to be done, etc., etc. If it is not possible, subsequently, if the patient experiences any pain or related aspects, etc., they are expected to look into. I think that is the protocol. Now the question is, because there is a complication, in my opinion, according to the understanding of the law, it may not be considered or construed as an epitome of medical negligence, unless there is evidence to show that the doctor either is not competent or experienced, or according to established medical practices, the doctor has failed to exercise the required standard of care. Only in those cases, the doctor can be held liable. But otherwise, because there is a complication as such, I personally do not think the doctor or hospital should be made.
Okay, okay. So, what I understand here is that in case of these known complications, two utmost important things being one, there has to be a written informed consent from the side of the patient. And the second thing is, in case of these known complication situations, what is most important is what measures were adopted by these doctors and whether they have taken utmost care. That is something that will be considered.
Absolutely.
Okay, okay. Very important. Just moving on to my next question, just an extension, should any adverse consequence ensue? So, how do the courts interpret and reach a conclusion about breach of duty?
Generally, what happens is the courts do take note of the adverse consequence for the purposes of deciding medical negligence liability, which I think that is not appropriate. It is for the simple reason the underlying condition of the patient cannot be ignored. In its totality, take the underlying condition and adverse consequence. In the process, the court has to come to a conclusion. Is there any breach of duty on the part of the doctor? And then rationalize the adverse consequence would not have happened, but for the breach of duty on the part of the doctor. I think that's the crux of the matter. That analysis, I think, is very, very crucial. Many a time, or sometimes we don't even we do not come across that kind of detailed scrutiny, but I think it's necessary.
Okay, okay. All right. Thank you, sir. And just moving on to my next question. Would the hospitals be vicariously liable for medical negligence committed by by the doctors or medical professionals who have been employed or retained by it? And just an extension to this, would the hospital be vicarious? Okay, so that's primarily my question: whether the hospital would be vicariously liable to such medical negligence cases.
Of course, I think the law is very clear. Not only medical professionals, even with regard to other healthcare service providers, it could even include admin, finance, etc., and various other people who render service for and on behalf of the doctors and hospital can be definitely legally made liable vicarious.
Okay.
However, I have one important point. I think in this platform, I must share my thinking. The very purpose of sharing is not to get a consensus, but to evoke thinking on those lines. There may be a possibility participants may agree, may not agree. But I think, in my opinion, there is a deserving case for a detailed thinking. I'll give an example. For instance, if a patient is treated either medically or surgically, more than 2 or 3 doctors, whenever there is a claim of medical negligence, the doctor under whose care the patient was admitted, or the surgeon who conducts a surgery, normally they are made liable, stating they are vicariously liable for the omissions and commissions committed by any other person. For instance, mop count, instrument count is an established protocol. Mop means the cloth that is used to absorb the blood, and instruments could be any instrument. It is normally undertaken by a nurse who is trained in that. Suppose if there is a gauze or mop is left over as a result infection, etc., undoubtedly the doctor can be made liable, the hospital can be made liable. But my line of thinking with regard to other specialist doctors is slightly different. Say, for instance, you are an anesthetist, I'm a surgeon. The complication arose on account of surgical procedure. Maybe I have failed to exercise the degree of standard of care which I am supposed to exercise. But if the case is filed against a surgeon and anesthetist, which I feel that is not appropriate, and they include anesthesia, and the liability on the part of the anesthetist is invoked on account of vicarious liability. In my opinion, that is not legally correct. For the simple reason, surgeon is one specialist, anesthetist is also another specialist. They do act in coordination, but they are independent doctors treating the same patient at the same time. Therefore, we need to look into the domain of activity. Vicarious liability cannot be simply extended to other doctors who are treating the same patient. I think that kind of line of thinking needs to be really, we need to take it forward. That's what I. But when it comes to hospital, or when it comes to with regard to nurses, etc., vis-a-vis the surgeon or anesthetist, etc., I don't have any problem. The vicarious liability can definitely be applied.
Okay, okay. So by and large, cases are filed against almost all or most of the treating doctors. So is this legally tenable?
I have one important observation to make. I wouldn't say that the case cannot be filed against all the treating doctors. In my opinion, a case can be filed against all. But even 2019 Act makes it very clear. The complaint must make out a case against each treating doctor vis-a-vis the outcome of the alleged medical negligence. That requires a great deal of research, information, insight. Whenever we read a complaint, we come across the allegation against one or two, but not against 3, 4, 5. But when once those doctors are also included, I always felt, I agree that the technical rules of CPC and Indian Evidence Act are not applicable before the consumer forums. But I think it is necessary to look into whether the complaint, does it stand legally correct against all the people who are named in the complaint or not. I think that is something that requires to be taken.
Okay, okay. Dr. Rao, you did mention about causa causans. I would like to understand a little bit more about how to prove this particular doctrine.
Causa causans, particularly the cause and effect, according to my understanding, it requires to be proved in the light of very cogent and reliable evidence. No doubt, as a matter of stand, Nikhil super specialty case of Honorable Supreme Court made it very clear that expert evidence as a matter of rule and routine need not be adduced in every case. I think that is something it is understand. Because for a patient to get expert evidence is very, very, very difficult. Whether you may say fraternity feeling or inaccessibility, etc., very, very. Even courts also may not, for the reasons known to them, may not take proactive steps to refer a matter to a medical board, etc., etc. As a consequence, if there is an insistence that in every case expert evidence is necessary, it may be difficult. However, causa causans can be best proved in the light of expert evidence. Because honorable judges are not trained the complex interface issues of law and medicine. Secondly, whenever we talk about expert evidence, please remember the Bolam test is the test what we follow as of now. No doubt, majority of the jurisdictions, including the jurisdiction of UK, there was a discernible departure or deviation from Bolam, Bolito, and subsequent couple of cases. And Australian jurisdiction, Whitaker. In fact, Honorable Supreme Court also, in Nikhil super specialty and other cases, Supreme Court did refer all the developments, including the Malaysian Federal Court judgment. However, the Supreme Court felt, no, in India, we have to follow the Bolam test. Now, what is Bolam test? Bolam test, to understand common sense. If a doctor appears before the court and informs the Honorable Court that whatever act or omission which is alleged to be negligence is not negligence because the similar practice is being shared or adopted by other contemporaries of the existing. That is what is the Bolam. Which means a doctor of qualified and experience will file an affidavit, written affidavit, and states considering the facts and circumstances, this is what I think. Now, if there is such an expert evidence, I mean, because of consumer court expeditious, at least to say so, there may not be an opportunity for cross-examination, etc., or interrogatories to be filed, etc. Now the question is, how actually it gets proved? If the doctor files a written expert opinion evidence, either through interrogatories or through cross-examination, if the doctor is examined, I'm sure the judge, the court is in a better position to understand how it can be done. Therefore, on one hand, Bolam test, there is a tremendous departure from the rest of the jurisdictions. But as of now, we are following. Therefore, we need to look into, and that is the best way to prove the complex issues of law in medicine.
Okay. Okay. Sure, sir. And sir, now I would like to move a little towards the criminal prosecution aspects. When it comes to criminal prosecution of doctors for medical negligence, so what is the current position of law?
Yes. When it comes to criminal prosecution, either under Section 304A, Section 304, 338, 339 of Indian Penal Code. Honorable Supreme Court's judgment in Jacob Matthews case is the law as matters stand. What is the law? The Supreme Court made it very clear that whenever either through FIR or a private complaint, a case is filed against a doctor or group of doctors, there must be an independent body or a doctor of the concerned specialization. He or she has to give evidence in writing to state that there is a prima facie evidence, or there is evidence to show that this particular conduct amounts to medical negligence. Without that evidence, neither complaint nor FIR is to be registered. That is what is the Supreme Court. And towards this end, we do face a lot of issues, because Supreme Court made it very clear that a civil negligence is different from a criminal negligence. And the strict proof is necessary. Normally, the method what in some of the jurisdictions of India, some police stations, they do refer these cases to either government doctors or a medical board, etc., and ask their opinion. And along with the opinion, the FIR gets registered, the complaint gets right. Now, in some other jurisdictions, the police refer the same matter to the state medical councils. And state medical councils, they conduct separate parallel proceedings. And they come to a conclusion whether there is evidence indicative of negligence or not. Suppose in a particular state medical council, it gives a decision. Yes, the doctors are negligent. On that basis, they produce this particular report and according. Here at this juncture, I want to refer a particular case. That is, a 28-year-old patient approached a particular doctor with abdomen pain, conducted tests, etc. 1 or 2 days he was hospitalized and he was feeling better, discharged. Thereafter, 3 days later, again he came and subsequently he succumbed to a particular infection after 2 days of hospitalization. During the course of second hospitalization, the issue was whether a particular test was conducted when he got first hospitalized. They realized that that test was not conducted. And accordingly, this information passed on to the patients, etc. They filed a FIR and everything, and accordingly, a particular process has started. The forensic doctor who conducted the post-mortem, he gave an opinion stating that this is on account of medical negligence, this, that, etc. In fact, that was challenged before the Honorable High Court, stating a post-mortem, a forensic doctor cannot be an expert doctor. The forensic doctor's domain is only confined to conducting post-mortem and identifying the probable cause of death. On that plea, the High Court has quashed the criminal proceedings. I think this is how some of the issues that crop up. But otherwise, when it comes to criminal prosecution, Jacob Matthews case requires to be mandatorily followed.
Okay. Sir, I just have a question, just an extension to these prosecution cases. Are there any specific challenges where when a counsel represents a patient?
In fact, in my personal experience, I want to mention the counsel representing a patient or a patient cause has more onerous duty, and it's a very, very challenging aspect. Ultimately, it boils down to 3 important aspects. Number 1, what is the evidence to show that such and such consequence has ensured, and what is the cause? Secondly, how do we convince the court? As a patient's lawyer, I may not get an expert doctor. I'm not saying it is impossible, but it is difficult. In such a case, what kind of evidence the doctors? And the third, I think a lot of insight and examination of medical records. Lot of insight from law and medicine interface that is required. If these three are there, I think the council will be in a very, very important position to defend the interest of the patient. But when it comes to the opposite party counsel, the responsibility and the kind of thing is definitely and relatively lesser when compared to a counsel who is representing the patient. There are very, very practical difficulties. And the law and medicine interface is a very tough subject. Unless we really understand and how these things, a lot of medical literature you have to read and you need to interact with doctors, then only you will get. I think that's where I feel medical counsels appearing for and on behalf of patients, lot of insight is this.
A lot of homework needs to be done in terms of the medical terms and understanding the whole, the procedures or the process or the complications that arise out of this. So much homework needs to be done by the council. Yeah. So I would just like to come back to our consumer law practice. To what extent, according to you, the 2019 Act has strengthened the process of delivering an effective dispensation of consumer justice with regard to medical negligence cases?
That's 2019. I think definitely it did strengthen. I don't think there is any problem or doubt. However, there is one thing, though healthcare is not specifically provided under the Act,
Yes.
Under the rules, Section 4, every matter that comes before the Consumer Commission requires to be referred to, Section 36 of the Act, it says, every matter must be referred to mediation.
Yes.
In the rules, under Section 4, there are some exclusions. One such exclusion is the first exclusion, that is, whenever any medical negligence cases leading to either death or disability. In fact, that is excluded. They don't come under the mediation process. I think that requires to be taken note of. In my opinion, those cases also must be subjected to mediation. The reason is, I'm not talking about the COVID context alone. I think even generally, the delay that takes place in consumer forums, it is absolutely problematic. Therefore, we need to really look into in what way that. Therefore, this is one aspect. Second one is, I think, no doubt, expert evidence, etc. There is a mention where, in tune with Nickel Super Specialty Supreme Court case. I feel there is a need for more proactive stance by 2019, where the commissions are empowered to refer the matters to neutral or third-party medical practitioners to get their opinion. I think these two required to be taken.
So, which is where you say in these complicated matters, also mediation can play a role with experts who come in as mediators and actually try to assist the parties. Okay, a very important point noted. Of course, I would have many more questions, but I think we'll have to leave it to the audience also. But in summation, I have one very important question for you. What are your 3 key recommendations to achieve the goal of transparent, effective, and an expeditious dispensation of justice with regard to these kind of cases?
Okay. Consumer Protection Act came into being with these 3 goals, objectives. But the practice indicates something contrary. Therefore, my first key recommendation is the infrastructure, the courts, the honorable judges at every level must be completed so that the courts function normally and dispose of matters as on time or at least with minimal delay. The first recommendation. The second recommendation is, when it comes to the medical negligence matters, The honorable members of the commissions, I think they require training and capacity building. In the case of state commission and a national commission, I think the possibilities are more in terms of understanding, comprehending. But when it comes to district commissions, we do find very, very difficult situations. I think training and capacity building. And the third one, I think this is something very, very crucial. Whenever there is an expert evidence, the honorable commissions at every level, they must take independent decision of that opinion. There may be a possibility of relying upon the opinion, absolutely fine. But if they find the opinion is not conducive, I think they should not really hesitate to discard that opinion and accordingly move forward. I think these are the three things which I suggest.
Okay, thank you. Thank you so much, sir. Sir, I would now like to open this forum for questions from the audience. So we will take questions if our audience have any. Audience, please share your questions on chat, or you could also raise hand and ask your question to Professor Jogara. We are now open to questions. Yes.
That's a very good compliment, and I am very happy about it. Advocate
Yes.
Miss Uma Pillai.
Yes.
Thank you.
Please do share your questions on chat, or you could also ask. You can raise hand and come on audio and please ask your questions. This has been a very, very informative session to all of us, especially with regard to medical negligence cases and also the interface of law and medicine, which has given us a lot of insights, a lot of important points, which I could not but, post these really important points on chat for the benefit of everyone. So any further questions, we would be very happy to take them. I'm not seeing too many questions. Yes. Anybody? Anyone for more questions? In the meantime, while they are posting their questions, Professor Jogara, is it okay if I could share your email address with the
Sure.
participants?
Please.
So that just in case they would like to reach out to you on the subject, they would be.
Sure. And if time permits, I want to have one case study I want to share.
Yes, sir. Please.
Can I do it now?
Yes, please, sir.
Yeah. This one experience of my practice life taught me a great deal. And I also wondered how the law operates in practice. The case revolves around very simple facts and circumstances. A pregnant mother expected normal delivery, but had to undergo cesarean section. Post-delivery, baby and mother were here, and they have been discharged. 6th post-operative day, the woman started experiencing the problem dribbling of urine. She came back to the doctor. Doctor gave some medicines, but did not get relief. Then referred to urologist. Urologist did something, but did not get relief. Then he has put a stent and accordingly kind of things, etc., etc. Now, the point is, when she underwent that stenting and thereafter she filed a case claiming medical negligence, etc. And the case went on well. The complaint was this particular dribbling of urine is because of medical negligence. That is the complaint. We have explained in detail in writing, version, affidavit, all the documents. And we mentioned the process is called kinking off. Post-transcervical, the cut for the purpose of cesarean, There is every possibility, ureters which left and right, the possibility of kinking off. When kinking off takes place, that may lead to fistula, VVF, vesico-vaginal fistula, and very, very problematic for the patient. Then we explained, etc. It is a known complication, everything. And it so happened in that district forum, there was a doctor who is a member. I was of the opinion he appreciates this, etc. And final day of arguments, he asked me a question. Evidence, medical literature records, everything is fine. But why did you conduct a cesarean section? He asked. But in the complaint, there is no mention anything about cesarean section has been conducted without any basis or something like that. There is no complaint at all with regard to cesarean section. Then I told Honorable Judge, cesarean section has been conducted because there was a fetal distress. Then he said, no, I am the only doctor. There are other members who are not doctors. You have to explain. I said, fetal distress is a condition where the fetus experiences some problems, either because of cord around the neck or amniotic liquor less in quantity, or FHR, fetal heart rate beat. Then he asked a question, fetal heart rate, whether your doctor has documented. I said, fetal heart rate has been observed every half an hour. No, has it been documented? Then I said, it is not documented. Then I made a mention. When fetal heart rate observed and the doctor clinically felt the need for the particular cesarean section, she has done it. The fact that it is not recorded does not mean fetal heart rate was not observed. That's what I said. Then Honorable Judge said, no, if the fetal heart rate is not recorded, it means fetal heart rate is not observed. And accordingly, he found, recorded medical negligence against the doctor and payment of compensation, etc. In the complaint, there is no mention about FHR. That is something a kind of experience for. There is no mention. Number two, a document is so important, which is which can defend the interest of the doctor. If the document is not there, it cannot. I think these are the two important points I thought I share.
Absolutely, sir. Number one, medical records, and number two, consent at every stage of the treatment. These are two very, very primary documentations which every hospital will have to consider, which every doctor has to consider. Sir, we have a couple of questions which have come in. I will just take these questions. There's one question from Chandni Kaur. Sir, you pointed out that there is a need to limit liability on one doctor rather than to all doctors treating the patient. Should it be done by the legislature or the courts on case-to-case basis?
In my opinion, legislatively, it is very difficult to formulate a law to that effect. It has to be done on a case-to-case basis, where the concerned commission, be it district, state, or national, considering whether there has been a case that is made out or not, at the time of admission of the complaint itself, it has to be decided. Suppose if I file a case against 3 doctors, the commission must ask, what is the allegation against Dr. A, Dr. B, Dr. C? Then accordingly they have to decide. But now what is happening? The moment admission is more a process, a formality. What happened? Medical issue notice. Or what happened in one particular, what happened? Surgery. Thereafter what happened? Either death or then issue notice. I think that is something, admission hearing must be taken very, very seriously. That's a very important question. In my opinion, it has to be done on a case-to-case basis by the commission. We don't require any legislative input to that.
Okay. Yeah, and there are 2 questions from Mr. Anand Kalyan. Number one, in criminal cases, what is the procedure to be adopted before registration of crime against a doctor in medical, as far as medical negligence case is concerned? So can we take this first question and then move to the second one?
Sure. I think Anand Kalyan, I know him because same name is my good friend also. Anand Kalyan, one thing I want to clarify. According to Jacob Matthews' case, when a complaint that is given, the complaint in writing must be supported by opinion evidence of a doctor of the concerned qualification and specialization. If that is there, a complaint or FIR can be registered and investigation can commence. Even with regard to the complaint before a magistrate, please remember the complaint must have that supporting written opinion evidence of a doctor of the concerned qualification and specialization. This is the procedure. If that is not done, naturally, by invoking Article 226, a writ can be filed because Supreme Court's mandate has not been completed.
Okay. And just proceeding to the second question by Mr. Anand Kalyan, whether the investigating officer is obliged to produce materials collected during investigation before an expert, before filing of final report, and if not followed the procedure, what is the consequence?
If it is not followed, the consequence is nothing but challenge before the High Court. Number one. Number two, normally if investigative officer, for instance, the complainant is not in a position to support or share any supporting corroborative evidence. In some of the jurisdictions, what they do, the inspector writes a letter to the concerned state medical council and sends all the papers and says, let the medical council give an opinion. If the medical council gives an opinion, then that will be taken to consideration. Or they can approach a particular medical board, government hospitals, and ask whether there is any evidence with regard to medical negligence as alleged or not. I think these are the steps that are required to be taken. If not complied, I think vulnerable to writ jurisdiction, where the proceedings will be quashed without any doubt.
Okay. Okay. So, apart from this, we just have one comment from Mr. Jagara, who says that it has been a very educative session, quite apparently with the vast experience that Dr. Rao comes with in this particular area of healthcare and healthcare law and ethics.
I think Jagara also, I know him.
Okay.
A known family friend and my junior, I think, by name. I don't know whether he is the same person, but I think name is very famous. Thank you so much, Mr. Jagara.
Thank you.
Yeah.
Thank you. So if there are no questions, I think we can come to an end of this session. Are there any further questions from the audience? We would be happy to take them. Yeah, looks like this was quite informative to them, and perhaps a lot of clarifications also with the kind of questions that we came up with.
For a presenter, good number of questions always keep us happy.
Yes. Yes. But I think I took the most of it, where I asked you all these questions on behalf of the participants.
Sure.
Yes, we have already. I have shared the email address of Dr. Rao on the chat. I could just reshare that with you.
Sure, please.
So here's the email address, and you could get in touch with Dr. Jogarao. So thank you very much, Dr. Jogarao, for being a part of this webinar with EBC Learning. Thank you for your time. Very much appreciate given the time and your busy schedules. But this was very, very informative. Given the vast experience that you come with, and I was really very particular of having this particular program on healthcare law, and none other than Professor Jogarao. Of course, I must also say that Professor Jogarao has been my teacher too at National Law School. So that's when I have known Dr. Rao for a very long time now. And thank you so much for this.
Always.
And we hope to have you on many more of these webinar series. Thank you.
Sure. Definitely. Thank you. All the best.
And thank you. And Advocate Uma has also mentioned, Madam, you have hosted the session. Thank you so much. Thank you. That's good. A double thumbs up. Yeah, thank you so much, ma'am. Thank you. Thank you, sir. And thank you, panelists, for being a part of this webinar event. And you could also watch this on YouTube. Thank you, sir.
Thank
And
you.
we end the session now. Thank you.
Sure, sure.